you for
No.
Rick and I want to be ready for you to pound that thing.
I'll call the meeting of Tuesday, May 20th of the State Board of Elections. It is 10 a.m. and if you'll all rise, we'll say the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right. Could I have a motion for the approval of the minutes of April 15th? Oops. Oh, we're all here. Roll call, please.
Ms. Mallory-Croft,
Present.
Ms. Craig,
Present.
Ms. Genovese, Ms. McCrory, Mr. Turbin.
Here.
Mr. Brett,
Here.
Vice Chair Donahue.
Here.
Chair Watson.
Present.
All right. Now, could I have a motion of the approval of the minutes of April 15th meeting?
So moved.
Second.
Roll call, Amy?
Ms. Mallory-Croft,
Same.
Ms. Craig.
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin.
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passed.
All right. Well, let's get this thing started and we'll have the report of the general counsel, please. Motions for reconsideration.
Well, good morning, everybody. We have quite a few appearances on file today, so we will launch right in. The first item is a motion for reconsideration. It's agenda item 2A1, vote Lyle Township Dems 25 CD4. And we have an appearance on file from Treasurer Robert Sachs.
I believe he's in Chicago. Jack?
Yes, he just raised his hand, I believe. He's coming up. Insert.
Excellent. Well, Mr. Sachs, I will read my recommendation and then you'll have an opportunity to address the board.
Okay.
So the board heard this case last month and ordered the committee to amend its D1 statement of organization to change its name to include the names of the offices sought by the candidates supported by the committee. Rule 100.10B5D provides in relevant part that candidates who exercise the option of forming a political action committee may not include the names of any of the candidates in the name of the political action committee. A political action committee must, however, include the name of the office that the candidates are seeking and the name of the political subdivision or unit of local government to which the office pertains. So in reaching its determination last month that the committee should amend its name, the board necessarily interpreted this rule to mean that the names of the offices sought must be included in the name of the committee, not merely listed on the statement of organization. In a motion for reconsideration under Rule 125.440D, if the case is not an appeal, the board is to consider whether a mistake of law or fact was made in the original board decision. Here, the board is well within its authority to rely on its interpretation of its own rules in determining that the name of the committee must be changed here. A different interpretation, however reasonable or unreasonable, does not rise to the level of a mistake of law. As such, it's my recommendation that the respondent has not provided a sufficient basis to grant this motion to reconsider under Rule 125.440D, and I recommend the motion be denied. If the motion is denied, I suggest giving the committee 30 days from the date of the order in this case to amend its D1 statement of organization.
Thank you, Marnie. Mr. Sachs, could I ask one favor? Could you turn to your left a little more? There you go. And we can see you and they can see you, and that just makes it a little better. So,
And if he can state and spell his name.
all right, and state and spell your name, sir. Thank you.
Robert Sachs, S-A-C-K-S.
You may proceed.
My position on this matter is that the the language of this, of the statute that was cited actually does not say that the political action committee must include the name of the office that the candidates are seeking in the naming of the committee. It says that the committee must include it, but it does not say it must include it in the naming, which is probably the reason why when I searched the state database of committees, slate committees formed for township races, there are literally scores, maybe hundreds of committees, none of which have ever adopted this or been forced to follow the standard of putting the names of all the offices in the naming of the committee. I would also point out that when you're talking about township races, it's particularly an awkward situation compared to, for example, a school board, a library board, park board, where everybody on a slate would be running for the same office. In Illinois townships, there can be as many as 5 different offices as there are in Lisle Township. So this would literally mean we would have to list supervisor, clerk, highway commissioner, assessor, and trustee. So that's 5 different things that would have to be included in the naming. And further, that if any change occurred, and this did happen to our committee, that if somebody was added or subtracted to the slate, we would then have to go back and reorganize everything. And this would include having to go to the bank and say, okay, we've legally changed our name. We are no longer what we provided to you on our EIN. So we have to close the bank account. We have to apply for a new EIN. We have to set up a new debit card. We have to go to, agents or, whatever you call them, organizations like ActBlue that collect money for us. We have to inform them. And this would be, sort of an ongoing thing. If somebody had to leave the slate due to illness or for what family reasons, whatever the reason might be, this would just be an onerous task to try to keep up with these changes. As it was, early on, we had another member on our slate who dropped off, and that forced us to then have to redo all of our petitions and then have to go out a second time into the community to collect signatures. But this is the standard that is going to be upheld. Then it's going to be, could be literally an ongoing thing, having to, constantly rework the D1. Each time we've amended our D1, the names of the offices being sought and the people standing for those offices were included in each amendment. Sometimes it meant subtraction, sometimes it meant addition, but it was always there. It was always available for the public to see. I feel that puts us in compliance with the law. The naming of our committee does not in any way mislead. It doesn't, we're not saying vote Lisle Township Dems and then we're actually supporting Republicans. We're, the people that are on our slate were, match the party designation. And again, the offices were all disclosed.
Thank you, Mr. Sachs. Is there a response to his comments?
Sure. So I mean, Mr. Sachs's arguments are not lost on me. I do think that, especially in the circumstance of a township, this could be an impractical rule to have to list all of the offices sought by all of the candidates under the PAC. And that is actually something that we are considering changing in the rule amendments that we're currently working on. That having been said, I don't agree that the rule right now doesn't require this. So I don't think that the board's ruling was in error. I think Mr. Sachs makes a good point that maybe this is not a practical rule. It's frustrating to have to change your EIN and frustrating to have to change your name. And that is something we can work on and fix, but not within the context of this case. It's something we can work on fixing in the future.
What about
I just was going to add one other element to this, which is that we are in the process of finalizing our committee. We plan to finalize within the next couple of days, whether that has any impact on the order.
what about the fact of other townships, like you mentioned, if he did a search and none of the other townships list the candidates as
So,
we're requiring.
so I agree that this is not an often enforced rule. This came up because someone filed an outside complaint. Campaign disclosure staff does not file internal complaints based on failure to include the names of the offices.
Do we have options here? Since, as he says, they're getting ready to change their name or to file, and if we're looking to change our rules, is there some room?
So the standard on a motion to reconsider is whether there was an error of law or a fact. And there was not an error of law or a fact. However, I mean, the fact that the committee is closing means that, you know, filing an amended D1 the same day it closes is really not even going to be a difficult thing. It can dispose of its funds, quickly change its name, and close. And Tom Newman, the director of our campaign disclosure department, you know, is available for calls to, you know, help in that process in any way it's happening. But here it seems like it's actually going to be quite easy for this committee to do as it shuts down.
Does that make sense to you, Mr. Sachs?
It's not ideal, but that's the only option available to us. I really do think that there's just the way the statute is worded. I think part of the brilliance of the way the statute was worded is that it did not say that the committee had to include the name of the offices in the name of the committee. So I do feel that there is just a completely different way of reading the words. The political action committee must, however, include the name of the office. The candidates are seeking the name of political subdivision or unit of local government to which the office pertains. That sentence does not say anywhere that it has to be in the name of the committee. It simply says it needs to be included there, as in put in the D1 and in all the amendments of the D1 to keep current with what the actual slate makeup is.
All right, Mr. Turbin?
Marty, do you have any idea how soon we can correct this?
Very soon. I know our legislative analyst, Heidi Poyer, is hoping that we might be able to get campaign disclosure rules before the board as soon as the June meeting. If not, likely the August meeting.
Thank you.
Do I have, I think we're in a situation where, member Brett, please.
Yes, is it possible for us to stay the effect of the order for, say, 90 days? And if the committee's been dissolved, then the committee's been dissolved and finalized out. If we have a new rule, then we have a new rule, but we haven't actually reached the merits of the reconsideration motion, because I think the general counsel makes a good point that we haven't met that burden. But can we stay this or kick it over for a few months and see what happens?
Okay, let me think through this really quickly. I'm trying to briefly think through if there might be an issue I'm not thinking of. I don't see why we couldn't continue this ruling on the motion for reconsideration until, say, the August or September meeting and take this up again at that time, although it may be annoying for Mr. Sachs he may or may not need to attend, depending on the circumstances and whether the rules have changed at that point. But I'm open to that option.
But I would be, in fact, willing to attend if there was any value in my being there, because actually I'm doing this mostly on behalf of all the other committees that would be, you know, theoretically faced with the same issue. I think it just is a burden that I'd like to see the board, you know, sort out.
Thank you, Mr. Sachs. So do we need a motion to that effect, or do we just continue it?
I don't know that we technically need to, but let's just do it.
All
So
right.
it's on the record and we don't forget.
Gotcha.
When we go back through the transcript,
I
that we've
appreciate
continued this to the September meeting.
Do I have a motion?
So moved.
Second?
Roll call, Amy?
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
yes,
If
Motion
you
passed.
said Mr. Jack, I approve.
All right. Thank you, Mr. Sachs, for your effort there. All right, Marnie, continue with 2A2.
Our next case is a settlement offer. We have several settlement offers up today. The first for which I have an appearance on file is agenda item 2A2, SBE versus Committee on Affirmative Leadership, Illinois Coal Association, 24AS8. I have an appearance on file from Kevin Morphew, who I assume is in Chicago.
He is
Oh,
here.
he's
He's there.
Hey, Kevin, how are you?
Hello.
So I will read my recommendation and then Mr. Morphew will have the opportunity to address the board. I just assumed you were in Chicago because you usually are.
Yes.
Okay, so here the committee is offering $3,000 to settle $12,000 or 25% of the fine balance for the delinquent filing of 4 Schedule A1 reports during the third quarter of 2024, filed between 47 and 53 days late. At last month's board meeting, the board denied this committee's motion for reconsideration on these fines, but expressed an interest in entering into a settlement for the outstanding fines. Just to refresh everybody's recollection, I'm going to give you a couple sentences on what we did last month, because obviously we've had a fair number of cases. So in that motion for reconsideration, the committee argued it failed to appeal the assessment because the committee did not receive the original assessment letter sent by certified mail. The committee's office was undergoing construction, its mail was being forwarded, and the certified letter was ultimately returned to the board. Further, the committee had argued it was entitled to an electronic filing defense because it did not realize the relevant report was not successfully filed until it received the final order. So that motion for reconsideration was denied. However, the board had expressed a lot of interest in settling this matter. So here the committee is not low dollar and the offer falls below 50% of the fine amount, both of which weigh against accepting an offer that's only 25% of the fine balance. So I ordinarily would not recommend accepting a settlement offer this low. However, given the board's statements last month, if the board nevertheless desires to reach a settlement with the committee for an amount below 50% of the fine, in calculating an appropriate fine amount, the board can consider that the committee's average receipts over the past 4 quarters is $15,000, resulting in a high receipt ratio of 80%, and that the violations did not occur within 60 days before an election.
Thank you. Mr. Morphew?
Yes, members of the board, thank you very much. We, at the onset, appreciate the ability to negotiate this fine, and also are very happy to hear at the last meeting of the interest that the board has in updating some of the notification procedures that these committees have to go through. It is our position we never received the mail. The mail was not placed in the mailbox. We have no way of knowing about this initial violation notice if the mail is not placed in our mailbox. Secondly, we notified the board. We did receive the final notice on April 26th, or I'm sorry, on March 26th. And that day I contacted Campaign Disclosure. We then began discussing. I was trying to determine what actually happened. I had receipts from my client saying, look, I filed this. What did I do wrong? So I was just trying to work with Campaign Disclosure in good faith. Just where did they mess up? Where did they mess up? And we determined that he did upload it onto the system, or he failed to take the extra step and click on a button that would have submitted the A1. And we sought to establish the electronic filing defense based on that. And we're told that we weren't timely with our notification, which was stunning to me because I contacted them the moment that I found out about this violation. I had been working with them. Where could this have happened? In fact, Tom Newman personally told me, he said, here's what happened, Kevin. You didn't electronically file it correctly. So he's telling me that I didn't electronically file it correctly. So now, but the rule says I have to notify. It was contemporaneous. The moment that I learned that we had an electronic filing defense was when the board told me. And then the board, the rule, the administrative rule concerning electronic filing reports, 100.150 C5D states that the board must then, after this contact is made by the committee, the board must confirm that contact by in writing. Board staff must confirm that writing, which never happened. So I don't know if that burden is on me to request the writing or if the board just does that on their own. I'm unclear on that, but I feel like we, in good faith, tried to comply at every step of the way, and that the fine imposed did not meet the crime in this case, where all efforts at all times were being made by this committee to make the filings in good faith. Even on the committee's printout, it says received by. There is again, the A1 was not filed. That was the detriment in this entire instance, but it does show that he did enter this in electronically on the board's website. So
I think the interesting thing is that from our meeting last month and knowing about not punching then, we have now corrected that where they will receive a receipt, correct, Tom?
which is great.
I know, and we've got to make sure the committees know that they get a receipt. So in future instances like this, we'll ask you for your receipt. But I mean, they need to know this, but I think we all appreciate what you're saying, Mr. Morphew. Do I have a motion or are there questions in regard to this?
Just a reminder, the offer is $3,000 to settle $12,000 in civil penalties.
Make a motion, we accept that off.
Second,
It's been moved and seconded. Roll call. Amy?
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turbin?
Yes.
Mr. Brett?
yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passed.
And briefly, I realized we didn't have Mr. Morse to spell his name for the record, if you wouldn't mind doing so.
MORPHEW.
Thank you.
Thank you, everyone.
All right.
You can get that check.
All right, Marnie, 2A3.
2A3, we have an appearance on file from attorney Perry Abbasi. It's SBE versus 36th Ward Dems, 23 AD 27. Is Mr. Abbasi in Chicago?
He's stepping up.
Okay, excellent. Well, I will read my rec.
Hang on, sir. We'll have Marty give her report and then you may speak.
Thank you. So here the committee is offering $5,845 to settle $11,690 in fines. So that's 50% for delinquent filing of 8 A1s during the fourth quarter of 2023, 2 A1s during the third quarter of 2023, and 1 A1 during the fourth quarter of 2022. Included in the fines, the committee is requesting the board settle are $800 in penalties assessed in case 23 AS 39. In May 2024, the committee filed an appeal of those penalties, and an appeal hearing was scheduled for October 29, 2024. However, no representative for the committee appeared at the scheduled hearing, nor have staff requests to reschedule been responded to. So this appeal hearing has been drawn out because no rescheduled date has been set. So here the offer meets the 50% benchmark, but it is well short on both the balance and receipt ratios, both of which are below 20%. The committee reports an average ending balance of just over $97,000 in the last 4 quarters. Here I recommend denying the offer as the settlement factors in Rule 125.450 weigh against this offer. However, the board does have discretion to weigh settlement factors as it sees fit. And if the board does accept the offer, I recommend conditioning the acceptance on the committee withdrawing its pending appeal in 23 AS 39.
Mr. Abbasi, would you state your name and spell it for the reporter, please?
My name is, first name is Pericles, Pericles. Last name is Abbasi, Abbasi. I go by Perry. And thank you, members of the board. The main bulk of the fines were from 2023, October and November, when there was an issue with the consultant for the committee. There was a new staffer there, and they didn't, in a timely manner, forward it to the committee to file the A1s. Since then, there have been no further violations. This wasn't immediately before an election, and an issue with those fines was at the time was there was no. We had filed a motion to reconsider on those because we hadn't received the notification to appeal initially. The committee has since corrected the email. It had the same email from when it was formed in, I believe, in 2020. It's now got an email that's regularly checked by the 36 ward committeeman, Committeeman Villegas. And as such, I have a check for the amount today for 5845, and the committee will withdraw the appeal that the general counsel had mentioned. And so, in light of the fact that and I'll also say the committee does have a new treasurer now, Mr. Carlos Guevara. I believe before the Alderman Villegas was also the treasurer, and that may have caused some issues, but it's got a new treasurer who's on top of it and focused on it. And like I said, there's a new email with the State Board of Elections that Alderman Villegas checks, and he forwards as soon as he gets something. So in light of the fact that there have been no subsequent violations, and again, this wasn't in the 60 days before an election, I would ask that the board accept the settlement, and I have the check today for it. Thank you.
Thank you, Mr. Abbasi. Do we have questions? Do you have a motion?
Recommend we accept what the general counsel is saying about the past due amounts and accept the offer of 50%.
There needs to be something about the,
And we could just note for the record that the previous appeal has been withdrawn.
all right. We have a motion. Second. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craddock,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passed.
All right. Should we continue or should we go with other people that are in attendance? What is your pleasure?
If I can ask quickly, is there anyone present on agenda items 2A, 4, 5, or 6?
Anyone here in Springfield? Anyone in Chicago? Jack, Jennifer?
Not appear so.
No.
These committees are all low dollar, so it is the recommendation that the settlement offers be accepted.
Can we take these three together?
Yes.
In a motion?
Yes.
I so move. All right, we have do I have a second?
Second.
The motion is on 2A, 4, 5, and a 6 that we accept their settlement offer. Roll call. Amy?
Ms. Ballard Croft,
Yes.
Ms. Craddock,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passed.
Now, 2A, 8,
If we could handle 2A7 quickly, just so I don't forget to go back to it,
no problem.
that would be fantastic. Is anyone present on 2A7?
Not in Springfield. Anyone in Chicago?
No.
Okay, the recommendation here is to grant the appeal as to 3 of the 6 civil penalties assessed.
Do I have a motion? So moved.
Second.
There's a motion and a second. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craddock,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passed.
All right, now we're at 2A8, appeals of campaign disclosures. We have Mr. Rice, I believe. You'll come up here. We'll have Arnie give her report and then you can read them off.
Great. So this is 2A8 SBE versus Livingston County Republican Central Committee, 24 AM5. I will read my recommendation and then, sir, if you can introduce yourself and spell your name thereafter before you speak, that would be lovely. This committee is appealing the assessment of civil penalties totaling $1,500 for the delinquent filing of two $1,000 Schedule A1 contributions during the first quarter of 2024, 48 and 28 days late, respectively. The committee has a previously stayed penalty of $25 for late filing of the September 2022 quarterly report. In the appeal affidavit, the committee's chair states that the delinquent filings were the result of an accounting error. I don't fully understand the explanation that was given by the committee, but the committee mentions the date of deposit and said that checks are not regularly given to the treasurer. The committee also said that the committee is staffed by untrained volunteers. I keep in mind that the committee bears the burden of proof in an appeal, and I was unable to understand exactly what defense this committee was advancing. Therefore, the hearing officer recommends, and I concur, that the appeal be denied for lack of a statutory basis. If this recommendation is accepted, the stay will be lifted from the previous penalty and $1,525 owed.
All right, Mr. Rice. Ugh. State your name and spell it, please.
Thank you. David Rice, R-I-C-E. And I'm the chairman of the Livingston County Republican Party. First of all, thank you. Appreciate your time. Thank you. I can understand why you were confused about that explanation because this has been a learning process. We're a small committee. I'm not disputing the facts of anything that you have in front of you as far as the timing of everything. What I would say is when I heard the term delinquent, technically delinquent, but we did file. It turns out we were unaware there's a difference between filing $999 contribution and a $1,000 contribution. Okay, so we tried to do the right thing. We weren't doing anything nefarious. That's where the accounting error maybe came in. We didn't realize. So in the hearing committee meeting, that's where we actually, first time we learned that there's an A1. We don't have attorneys. We don't have consultants. We have a bunch of volunteers in a very small committee. The fine for us is very excessive. It constitutes approximately a third of all of our assets. And I say our assets, I'm here as a steward of these assets. They're not mine. We could easily say, write the check, it's $1,525, go ahead. It doesn't hurt me. But it does hurt the people that gave the money. So I'm throwing ourselves on your mercy to say, please don't punish those people for our mistakes. We're trying to learn. 2022, that first one, we had an overturn of our committee. I came in, a new treasurer came in, et cetera. We were fortunate to even be able to figure out how to access our bank accounts, get our forms changed, access. We learned, our treasurer's done a very good job for a volunteer learning the state's board electronic filing process, et cetera. I would ask the committee, I'm going to ask for the whole thing to please absolve the entire $1,500. I took the day off work. I'm a volunteer. I've come all the way down here. I'm asking for the whole thing. I understand you'll have a different decision perhaps, but I'm going to ask for the entire $1,500. If we could use this as a learning experience, a teachable moment, it certainly has done its job. This is something we'll never forget, whether we have to pay the $1,525 or not. It's not going to happen again, at least under our current committee's watch. So I don't know that I have anything else to add other than we made a mistake. We're learning. We've never made the same mistake with the filing of the D1 late once we got our feet under us and we learned that we were making a mistake. So I think we can learn from our mistakes. So I'll close with that.
Are there questions? I think, Ms. Rice, we can all appreciate what you're saying. Do we have?
I do have a question.
A question, member,
Right. Would you be able to do that? Would you be able to make an offer for at least 50%?
So this morning, an hour ago. I didn't even know it was such a possibility, see? I could, 50% is better than 100%. 0% is better than 50%. It's up to you. There was an offer made for 25% from an attorney, from a large committee, et cetera, that was accepted. Could I counter with the 25% offer?
You make an offer.
Is that your offer?
I'm
Yes, sir.
sorry, I'm
She's figured.
calculating 25%. All right, so that would be $375. So under these circumstances, this committee is low dollar. Their current balance is $5,316.10. However, normally a low dollar offer, we consider the amount of that the committee has. Here, the fine is less than 50% of what the committee has. So I tend to think we would look for a 50% offer. However, the board has discretion to consider the factors, the fact that this was an inadvertent violation, if it would like to deny the appeal, but accept the lower settlement amount of $375.
Do I have a motion? So moved.
Second.
Roll call, Amy.
Ms. Bellicroft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Griffin, Mr. Turbin.
Yes.
Mr. Brett,
Yes.
Mr. Donahue,
Yes.
Chair Watson.
yes.
Motion passes.
Motion passed. Thank you very much.
Appreciate
We
your
appreciate
using discretion.
your work. Thank you. All right. Where do you want to go next? You want to do the people that are here or?
Yes, let's
Okay.
do that. The next appearance I have is agenda item 2A18 SBE versus Friends of Lamont Williams, 24 AS 51. We have an appearance by Mr. Williams. Is he present?
He appears to be walking up.
Yes.
Excellent.
All right.
So-
Mr. Williams, we'll have you speak after Marnie makes her comments, and if you'll, when you do, state your name and spell it, please. Marnie first.
Great, thank you. So here the committee is appealing a $1,400 civil penalty assessed for the 14-day late filing of a Schedule A1 report for a $10,000 contribution received during the third quarter of 2024. At the appeal hearing, the candidate and attorney for the committee explained that reporting violations, including the delinquent A1 at issue here, were the result of staff turnover and delays in communication and receipt of electronic notices from and by the committee's treasurer. The hearing officer recommends, and I concur, that the appeal be denied for lack of a statutory basis. The committee has previous unpaid penalties of $330. So if this appeal is denied, $1,730 is owed.
Mr. Williams, please.
So I'm Lamont Williams, L.A. apostrophe capital M-O-N-T, last name Williams, W-I-L-L-I-A-M-S. I am the candidate for this committee. So I'm not here to counter any of the facts that were recited just now, articulated by the board. Our basis of our appeal, we were just asking for leniency, as it was spelled out just a few seconds ago. We did have some turnover. We are actually in the process of getting a new treasurer. The treasurer wasn't receiving the email notifications for the quarterly reports. And it's also, when it came to our attention, you know, I personally took action by coming down to the Board of Elections office here in Chicago to amend those A1s that weren't filed. And in the process of doing that, however, I filed my appeal. I received another letter in the mail from the Board of Elections saying that there were other penalties because I had amended those that I was told to amend. So I have those now. I haven't filled out an appeal for those, but I'm pretty sure I will be in front of you all in a month or so because of those penalties as well. We're just asking for leniency. If there's an opportunity for us to make a settlement offer, we'd like to take that route as well. Again, you know, our errors have been because we just were not receiving the communications until they were physically mailed to my home address.
Has that been corrected?
Yes,
Your
so
email has- So those have all been, you are getting things now when needed?
yes, ma'am. We're getting things now, and I've updated the contact email on the IDES login. So we're now getting things. I'm getting them directly electronically now.
Mr. Williams, are you prepared to make a settlement offer at this time?
I am prepared to make a settlement offer for this for the 1730. Yes, I'm prepared to make it.
If you would make that offer, you've got to tell us what you're thinking.
I'm prepared to make an offer. I can't do the math as quickly in my head, but for 50% of the 1730.
Okay, Marnie's doing that.
Someone want to do it for me, Tom?
865.
We have a calculator in the back of the room.
Yeah, I can do long division, but I also have Tom.
$865, Mr. Williams?
That would be my offer if it's accepted by the board.
Thank
I
you,
would-
sir. Do we have a motion to that effect then?
Yeah, I would move that we accept the settlement offer of 50% for $865.
Yes,
And deny the appeal?
and, all right,
Second.
Second.
all righty. Roll call, Amy?
Ms. Ballarcroft? Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Turbis?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passed.
Thank you, Mr. Williams.
And if I could just make very clear for the record, the $865 offer accepted is only for the $1,730 in penalties. I understand there are still different penalties coming down the pike, and those are not included in this $1,730 amount that was settled for $865.
Are you aware of that, Mr. Williams?
Yes, and I didn't know if I could speak to that, but I think those penalties, arose and they stem from this underlying penalty. When I went to the board, the office here in Chicago to correct the initial penalties that we're discussing today, I was told to amend and add, I think they wanted me to add some information for some of the contributions I received. I made those corrections. They said when you file your next quarterly report, just include those updates. When I did that, I want to say within a week, I received notification that I had these other penalties assessed from those updates. So basically those penalties that will, I guess, come later or subsequent to this meeting, all
Well,
stem from the same issue.
There'll be a hearing and a discussion of that can be worked out, but just so you're aware that what you're dealing with and dispatching with today is just these issues.
Yes, ma'am. And just some clarity for me, since I'm before you all now, just as a matter of course and protocol, should I just go ahead and file those, the appeal and everything, the documentation that I need for those penalties now?
Whatever, yes, the sooner you do things and talk with the department, the better off you are.
Okay, thank you.
All right?
Thank you.
You can talk to Andy up there right now. He's in the back of the room.
I see him.
All right, next we have 2A19.
I don't have an appearance on file for 2A19,
Okay,
but I do
there's
for
a bleed
2A.
over in the yellow. So say 2A20.
So 2A20, we have an appearance by the candidate. This is Christian for 22nd Ward, 24 NF 91.
Yes.
Is the candidate present?
Yes.
There he is. Okay, sir, I'm going to read my recommendation and then you will have an opportunity to address the board. Here, the committee is appealing a total of $3,000 in civil penalties assessed for the 241-day late delinquent filing of the December 2023 quarterly report, the 201-day late filing of the March 2024 quarterly report, and the 119-day delinquent filing of the June 2024 quarterly report. The committee also has a previously stayed $250 civil penalty assessed for the delinquent filing of the September 2023 quarterly report for a total of $3,250. The candidate's appeal affidavit said that the candidate did not file the report due to the correspondence from the board being sent to the treasurer, not the candidate. At the appeal hearing, the committee treasurer appealed and stated that board correspondence was sent to the wrong mailing address and that the committee never went over the $5,000 threshold. None of these reasons is a legal justification for failure to file a quarterly report, however, as it is due quarterly, regardless of whether the committee receives an email reminder before the deadline or a reminder letter by mail after the deadline is missed. Here, board records indicate correspondence regarding quarterly report filings were indeed sent to the email address provided on the committee's D1 statement of organization, and letters were mailed to the committee's address that was on file with the board following each missed filing deadline. Also, for your awareness, the committee filed a final report on May 7th, 2025, and has closed. The hearing officer recommends, and I concur, that the appeal be denied for lack of a statutory basis. And if the appeal is denied, the stay is lifted on the previous $250 penalty, making $3,250 owed. And if the committee remains closed for 2 years from the date of the final order, the fines will expire.
Did you hear that, Mr. Christian? For final
Yes.
statement?
Why don't you state and spell your name for the record?
Yes, my name is Christian Armendariz, Kristian, last name Armendariz. Permission to speak?
Yes, go right ahead, sir.
Yeah, we are aware that we failed to file the correct documentations. A quick background story, this is my first ever political campaign I'm a part of. I have no experience whatsoever, neither did the treasurer and some of our volunteers. So to us, this was a learning process as we were going. Later on the campaign, I found out that I did not have to file a political organization or committee due to the fact that my committee did not raise $5,000. If anything, we raised less than $3,000. And it was tough, asking constituents for their money, which is why I'm here asking the board if they could accept a counter offer. I know our committee failed to provide the documentation in time, but like I said, we are inexperienced when it comes to things like this. And we are aware that we failed, and we're willing to pay some type of fine. Our committee spoke that we have $500 if possible, if the board is willing to accept that.
Christian, your committee was dissolved. Am I correct in that?
I believe it's still active. It's not dissolved.
Do you intend to run again in the next 2 years?
Yes.
In the next 2 years?
And 2026, 27 would be the next municipal elections.
Then how did
he find out?
yeah.
There was a final report filed. So
You filed a final report, which
closes the
tells
committee.
us you've closed your committee. Now, you can run again, and then wait a minute.
No, we can't, not in the next 2 years.
Yeah,
Unless this fine is settled, but it sounds like he's offering $500.
okay. Are you offering $500 to settle this?
Yes.
And this is a low dollar committee, so a $500 fine would be acceptable under our factors.
Do I have a motion?
So moved.
Second.
So to clarify, the motion is to deny the appeal and accept the settlement offer of $500 in satisfaction of the $3,250 in civil penalties.
Yes.
And may I make a suggestion that someone speaks to him about his final out campaign? And if you'd like to reopen that, or the best way to do that.
Yeah. Christian, I talked to Andy Nauman in the back of the room. He could just give you a little idea. We've had a motion And a second, so roll, Amy.
Ms. Ballard Croft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson,
yes.
motion passed.
Mr. Norman was actually out of the room, so I just want to make sure. You, okay, all right, got it. You can touch Mr. Norman.
All right. Next, we have. Shall we finish in this category?
Yes, can I make sure that no one is present on agenda items 2A, 9, 10, 11, 12, 13, 14, 15, 16, 17, or 19?
There's no one in Springfield, anyone in Chicago?
No.
In that case, the recommendation is that all those appeals be denied.
I have one question,
Oh,
Mr. Craig.
okay. Okay, I just would say on 17, I have a note that we recommend that they final out. And on 19, I have a note that that's going to be stayed. If I'm correct on those.
Let me just double check for you.
17, I have a note that we need to recommend that they final out. It's my recommendation for that one.
It's just a suggestion.
Yeah.
I have in my notes here that if the candidate does intend to close the committee, the penalty appealed and any others due in owing would be subject to the abatement process following the final order. But it hasn't closed yet, so it's up to the committee to decide whether to close.
Okay.
And then your
And
other
then 19,
question,
would that be stayed?
19. Bear with me for 1 second, please.
Sure.
It's a $60 civil penalty. And yes, it will be
Okay.
stayed, and that is automatic under our rules. It's not
Perfect.
something that
Okay.
the
I
board needs
will-
to vote on.
Make the motion, all of those as one to deny.
Do I have a second?
Second.
Roll call, Amy?
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson,
Yes.
motion passed.
Marnie, where do you want to go next?
So under other campaign disclosure items, agenda item 2A21, we have a list of assessments requiring board orders on pages 129 to 135 of your packets.
All right. And we don't need any motion?
We do need a motion to enter those final orders.
On 2A21, correct?
Correct.
Do I have a motion to that effect?
So moved.
Second.
Roll call, Amy?
Ms. Ballard Croft,
Yes.
Craig.
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson,
Present.
motion passed.
Marnie?
And agenda item 2A22 is informational. It's a list of all the good folks who paid their fines. So before we talk about moving into closed preliminary hearings, I only have appearances on file for agenda item 2A26. I am wondering, is anyone present?
We have one for 2A24.
Okay, and is that person the complainant or the respondent?
He is the respondent, he's here.
Okay, all right. So the board could consider a motion to dismiss for want of prosecution, agenda items 2A23 and 2A25.
Do I have a motion to that effect?
So moved.
I have a second.
Second.
Roll call, Amy?
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson,
Yeah.
motion passes.
All right. We will I need a motion to move into executive session. Do I have such a motion?
Can I state the motion for you
yes.
really quickly? Is there a motion to move into complaints following closed preliminary session in a closed executive session pursuant to section 9-21 of the Election Code and section 2C4 of the Open Meetings Act?
Do I have a motion?
So moved.
A second. Second,
Second.
roll call, Amy.
Ms. Bellarcroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Kervin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
yes.
Motion